Alex here with part 118 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's a video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex-parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. Those are dog ears in the background. I'm not going to move him unless he starts making noise. I'll just continue the video. Anyway, this video goes into a motion that I filed in the Supreme Court that has to do with that what I thought was a clerical error or an inconsistency in the Supreme Court's opinion in that first paragraph. I already talked about this a little bit in part 113 of the My Docket series, and I mentioned that it might seem confusing to the average person or contradictory, but in that first paragraph, if you guys can recall, the Supreme Court of Nevada says that my ex was given a fictitious address based on evidence of DV. And then in that same paragraph later down, they say that I can file a petition for writ of mandamus in the district courts, and at that point in time, if my ex can prove that I have perpetrated DV. And that's the whole inconsistency. It's like, hold on, in the first couple of sentences, you said that she has evidence of DV, and then later on in the paragraph, you say that she has to get an opportunity to prove it. So to the ordinary person that's not an attorney, they're going to think something's wrong here, because does she or doesn't she have evidence? But now, in 2020, given everything that I know, I can understand that evidence means different things in different contexts in the court system. They have the sort of general rule, which is that it's not even just documentation and photos and video, it's even testimony from a witness. Even that counts as evidence. And then we have this niche sort of area with my case where in the context of the confidential address program, evidence is defined by a statute. And it's because of that statute that the whole case came in and went to the Supreme Court. It's that specific law that declares the piece of paper evidence that actually led to the Supreme Court stepping in and trying to clarify things. Anyway, this video goes into me trying to file a motion to get the Supreme Court to change that opinion, to clarify that first paragraph. And it doesn't go anywhere, it gets denied. But I don't want to skip anything in the My Docket series. I promised not only once, but maybe 2 or 3 times that I would go over every single filing, every single hearing. Nothing was going to be skipped in the My Docket series, and so that would include this document. As innocuous as it is, it's probably going to be a very short video in the My Docket series, but I don't want to skip it, so we're going to go ahead and go into it. So let's go ahead and take a look at what I have filed. Here we have my motion to make a minor amendment to the opinion. First paragraph is standard introductory paragraph. I erroneously call myself the petitioner. I'm actually the appellant. No, wait, I am. Okay, so this isn't an appeal. So that's not an error. This is a petition for a mandamus, so I am actually the petitioner. Okay, so petitioner, I identify myself as appearing in proper person, which means I don't have an attorney, and I indicate that I'm filing a motion to make an amendment to what appears to be a clerical error in the court's recently entered authored opinion. First section is the apparent clerical error. Justice Cherry's opinion, it is implied that additional fact-finding is needed to determine whether I am a perpetrator of DV, and I cite that portion of the opinion. And then I go into another section of the opinion where the same justice says nothing in the record establishes the specific grounds on which the restraining order was sought or the basis for the grant of the order. And then I also point out the second sentence of the opinion, which states that my ex properly obtained based on evidence of DV. So this is all the stuff that I mentioned earlier in the video, that these things aren't really consistent. They are contradictory to the average person using plain English, but under the law, it's actually exactly what happened. To attorneys and judges, that was evidence because a statute said so. And to us, that's not evidence that's confusing, especially given the fact that in the next couple of sentences they state that she has to prove it. So it's like, we think she's got evidence, so she's proved it, and then on the other hand, she's supposed to prove it. Anyways, I already went over this. This is confusing to us, but it's what attorneys and judges are used to. Anyway, I'm suggesting a sentence more consistent with the entirety of the opinion. And then in my conclusion, I state that it's not likely the Supreme Court would have delineated a procedure by which it could challenge the issuance of a fictitious address if it had also found that my ex was a perpetrator of DV. Okay, next we go into the order denying my motion to amend the opinion. I'm not sure that they actually, let's see what they state. I have moved the court to amend the second sentence, which states that the real party in interest, quote, properly obtained, blah, blah, blah. I contend that the statement is not consistent with the remainder of the opinion, which explains that I can challenge the issuance of the fictitious address. And they state in the next sentence that, as explained in the opinion, the restraining order submitted was evidence of DV for the purpose of... See, they actually are contextualizing it. So let me read this a little bit more slowly. As explained in the opinion, the restraining order submitted by my ex in support of her application for a fictitious address was, quote, evidence of domestic violence, unquote, for the purposes of obtaining a fictitious address, but was not conclusive evidence that DV had previously occurred. So if you read that again, you'll see what they're talking about. The Supreme Court is stating that it was evidence of DV for the purposes of getting a fictitious address only, but it was not conclusive evidence that DV actually occurred. Still, to an ordinary person, that's still really confusing because we see evidence as evidence as evidence. But they're saying that in different contexts, evidence is a different thing. So I guess this is a good lesson for my viewers. It's a good thing I didn't skip this video because it goes to show you how even in the same sort of area, which is the law, even in that area, there is sometimes different definitions for different things, and they can be so contradictory that you can end up in the Supreme Court getting clarification. So yeah, I mean, you guys can also see how this can really mislead people because a lot of people might think, well, she got this fictitious address based on evidence of DV, so he must have committed DV. And it's like, no, I didn't. Anyway, here you go. I mean, this is sometimes the craziness of the court system right here before your eyes for you to read for yourself. It's nuts. Anyway, going into the next document, notice of entry of order. Why am I entering this? Let's see. Notice is hereby given that so this is, okay, I remember why I filed this. So I was concerned that somebody might review the Supreme Court docket and wonder whatever happened of this case. And so I filed this notice stating that my ex's fictitious address had been canceled. This is not really an appropriate thing to do. Like, I can understand that I'm concerned somebody might read the docket and think something that's not consistent. And so I want to let people know who read the docket, hey, this address was canceled. It was really nice of the Supreme Court to file it because they could have rejected it. But for whatever reason, they didn't reject it. They went ahead and filed it. And I just want to let you guys know, use the docket for the purposes as to what it's intended, which is to litigate a case. Don't do stuff like this just to sort of help other people. I mean, most people aren't going to read the docket anyway. It's not really supposed to be like a public posting, like a bulletin board or anything like that. So if I could go back in time, I wouldn't have filed this because I have a lot of respect for the court system now that I didn't have back then. And I also didn't understand this back then. I thought that this was totally fine. You could post something into the docket just so people can see. And, you know, it's kind of like you're trying to exonerate yourself almost because you've gone through years of being falsely accused of something. And so you're emotionally charged. I know I was. And it's like, oh, no, I've got proof. I've been exonerated. Look. And I can see why I did that. But knowing what I know now, I mean, I wouldn't do that. Anyway, next we have the notice in lieu of remittitur. The remittitur, guys, is like a receipt that the Supreme Court transmits down to the lower court to tell them, hey, here's what we decided. We're done with this case. You can get your jurisdiction back now. But in a writ petition, that doesn't happen. The lower court's not divested of jurisdiction. And so instead of a remittitur being issued, the Supreme Court will issue a notice in lieu of the remittitur because it's not an appeal. It's something else entirely. If you want to know more about why this matters, watch my video, Jurisdiction Divested on Appeal, because I explain more of the technicalities in that video. Going into the aftermath, I filed two documents. Those were free filings, so I incurred $0 in costs. My ex's attorney didn't file anything, and so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney probably wouldn't have even read this. I doubt she cared, so I'm going to leave her attorney fees at $0. The government didn't file anything, so they incurred $0 in costs, and the government, I doubt, would have cared about any of these filings as well. So I'm sure that the government also incurred $0 in attorney fees. As with my previous videos, if you have any questions, feel free to post them down in the comments below, and I will see you guys next time.